Plessy vs. Ferguson of 1896. Transcription of the judgment of the Supreme Court of the United States in Plessy vs. Ferguson. Supreme Court of the United States, number 210, October term, 1895. Homer Adolph Plessy, plaintiff in error, versus J. H. Ferguson, judge of Section A Criminal District Court for the Parish of Orleans, in error to the Supreme Court of the State of Louisiana. This cause came on to be heard on the transcript of the record from the Supreme Court of the State of Louisiana, and was argued by counsel, on consideration whereof it is now he ordered and adjudged by this court, that the judgment of the said Supreme Court, in this cause, be, and that the same is hereby affirmed with costs, per Mr. Justice Brown, May 18, 1896, dissenting, Mr. Justice Harlan. Transcription of opinion of the Supreme Court of the United States in Plessy vs. Ferguson. U.S. Supreme Court Plessy vs. Ferguson, 163 U.S. 537, 1896. 163 U.S. 537 Plessy vs. Ferguson. Number 210, May 18, 1896. This was a petition for writs of prohibition and certiorari originally filed in the Supreme Court of the State by Plessy, the plaintiff in error, against the Honorable John H. Ferguson, judge of the Criminal District Court for the Parish of Orleans, and setting forth, in substance, the following facts. That petitioner was a citizen of the United States and a resident of the state of Louisiana, of mixed descent, in the proportion of 7/8 Caucasian and 1/8 African blood, that the mixture of colored blood was not discernible in him, and that he was entitled to every recognition, right, privilege, and immunity secured to the citizens of the United States of the white race by its Constitution and laws, that on June 7, 1892, he engaged and paid for a first-class passage on the East Louisiana Railway from New Orleans to Covington, in the same state, and thereupon entered a passenger train and took possession of a vacant seat in a coach where passengers of the white race were accommodated. That such railroad company was incorporated by the laws of Louisiana as a common carrier, and was not authorized to distinguish between citizens according to their race. But, notwithstanding this, petitioner was required by the conductor, under penalty of ejection from said train and imprisonment, to vacate said coach and occupy another seat in a coach assigned by said company for persons not of the white race, and for no other reason than that petitioner was of the colored race, that, upon petitioner's refusal to comply with such order, he was, with the aid of a police officer, forcibly ejected from said coach, and hurried off to, and imprisoned in, the parish jail of New Orleans, and there held to answer a charge made by such officer, to the effect, that he was guilty of having criminally violated an act of the General Assembly of the State, approved July 10, 1890. In such case made and provided, the petitioner was subsequently brought before the recorder of the city for preliminary examination, and committed for trial to the Criminal District Court for the Parish of Orleans, where an information was filed against him in the matter above set forth, for a violation of the above act, which act the petitioner affirmed to be null and void, because in conflict with the Constitution of the United States. That petitioner interposed a plea to such information, based upon the unconstitutionality of the act of the General Assembly, to which the district attorney, on behalf of the state, filed a demurrer, that, upon issue being joined upon such demurrer and plea, the court sustained the demurrer, overruled the plea, and ordered petitioner to plead over to the facts set forth in the information, and that, unless the judge of the said court be enjoined by a writ of prohibition from further proceeding in such case, the court will proceed to fine and sentence petitioner to imprisonment, and thus deprive him of his constitutional rights set forth in his said plea, notwithstanding the unconstitutionality of the act under which he was being prosecuted, that no appeal lay from such sentence, and petitioner was without relief or remedy except by writs of prohibition and certiorari. Copies of the information and other proceedings in the Criminal District Court were annexed to the petition, as an exhibit. Upon the filing of this petition, an order was issued upon the respondent to show cause why a writ of prohibition should not issue, and be made perpetual, and a further order, that the record of the proceedings had in the criminal cause be certified and transmitted to the Supreme Court. To this order the respondent made answer, transmitting a certified copy of the proceedings, asserting the constitutionality of the law, and averring that, instead of pleading or admitting that he belonged to the colored race, the said Plessy declined, and refused, either by pleading or otherwise, to admit that he was in any sense, or in any proportion a colored man. The case coming on for hearing before the Supreme Court. That court was of opinion that the law under which the prosecution was constitutional and denied the relief prayed for by the petitioner. Ex parte Plessy, 45 Louisiana Civil Code, annotated 80, 11 Southern Reporter 948, whereupon petitioner prayed for a writ of error from this court, which was allowed by the Chief Justice of the Supreme Court of Louisiana, Mr. Justice Harlan dissenting. A. W. Turgiandis F. Phillips, for plaintiff in error. Alex. Porter Morse, for defendant in error. Mr. Justice Brown, after stating the facts in the foregoing language, delivered the opinion of the court. This case turns upon the constitutionality of an act of the General Assembly of the State of Louisiana, passed in 1890, providing for separate railway carriages for the white and colored races. Acts 1890, number 111, page 152. The first section of the statute enacts that all railway companies carrying passengers in their coaches in this state shall provide equal but separate accommodations for the white and colored races by providing 2 or more passenger coaches for each passenger train, or by dividing the passenger coaches by a partition so as to secure separate accommodations, provided that this section shall not be construed to apply to street railroads. No person nor persons shall be permitted to occupy seats in coaches other than the ones assigned to them on account of the race they belong to. By the second section it was enacted that the officers of such passenger trains shall have power, and are hereby required to assign each passenger to the coach or compartment used for the race to which such passenger belongs. Any passenger insisting on going into a coach or compartment to which by race he does not belong shall be liable to a fine of $25, or in lieu thereof to imprisonment for a period of not more than 20 days in the parish prison. And any officer of any railroad insisting on assigning a passenger to a coach or compartment other than the one set aside for the race to which said passenger belongs shall be liable to a fine of $25, or in lieu thereof to imprisonment for a period of not more than 20 days in the parish prison. And should any passenger refuse to occupy the coach or compartment to which he or she is assigned by the officer of such railway, said officer shall have power to refuse to carry such passenger on his train, and for such refusal, neither he nor the railway company which he represents shall be liable for damages in any of the courts of the state. The third section provides penalties for the refusal or neglect of the officers, directors, conductors, and employees of railway companies to comply with the act, with a proviso that nothing in this act shall be construed as applying to nurses attending children of the other race. The fourth section is immaterial. The information filed in the criminal district court charged, in substance, that Plessy, being a passenger between 2 stations within the state of Louisiana, was assigned by officers of the company to the coach used for the race to which he belonged, but he insisted upon going into a coach used by the race to which he did not belong. Neither in the information nor plea was his particular race or color averred. The petition for the writ of prohibition averred that petitioner was 7/8 Caucasian and 1/8 African blood, that the mixture of colored blood was not discernible in him, and that he was entitled to every right, privilege, and immunity secured to citizens of the United States of the white race, and that, upon such theory, he took possession of a vacant seat in a coach where passengers of the white race were accommodated, and was ordered by the conductor to vacate said coach and take a seat in another, assigned to persons of the colored race, and, having refused to comply with such demand, he was forcibly ejected, with the aid of a police officer, and imprisoned in the parish jail, to answer a charge of having violated the above act.